In respect of SA or CO? CO. Achha. Determination. But as regards to specifically this one?
Yes. That has been.
It was passed on contest.
Yes,
So no.
Yes,
So the other side is required to be
no,
informed.
We have given 3 times notice, 3 times they appear to be recorded.
No, as regards to mentioning, in respect of recalling,
No, that we have seen.
has it been served? Is there any endorsement?
For recalling of an order dated such a time.
Has that been informed to the other side?
Yes, all this.
Is there any endorsement herein or anything
No,
of that sort?
was taken up in the lordship will find it was taken up by the lordship. But the date when
It will come under the heading, if at all, it will come under the heading to be mentioned, and on that day, Learned Council, an affidavit as regards to service is required to be filed.
So today I will again give a notice to the government collector. Thrice we have given notice and even the copy.
If this bench has determination, there is no wrong in hearing it. But that should be heard in presence of the other side.
No doubt of it. But rather it will be convenient for us if the other side stays. This is the indicator to the
ওটা নিয়ে নিন রেকর্ডটা রিকুইজিশন করুন দেখবেন
department. In now, it is ready for hearing, and I have no application is pending, only for the final year. I am for the respondent, and I am the sufferer. It is a case for a declaration suit was there, and we have owned, but the appellant was. Yes. Yes.
Decreed by the trial court, affirmed by the first appellate court.
And we have the all records. There is a paper book with us. All High Court's order.
Paper book has been prepared
original prepared by
appellant.
Respondent.
Respondent. Was there any direction upon the respondent? Was there any direction upon the respondent? Prepare the paper. Have you informed the appellant that it will be mentioned?
Yes, it will be mentioned.
There is endorsement to that effect.
And here.
There is endorsement to that effect.
Today's was not. It was previously mentioned that it will be listed on 28th. And as per your direction, affidavit service also.
How can the matter be listed if the record is not here?
That is why I am mentioning. That is why I am mentioning before the time.
I don't think that there was any assurance given from this end that the matter will be listed on this. Until unless the record is available.
No, it was your lordship directed me to even affidavit service also. Again, I have informed that appellant. And that service also ready with me. Live with you.
Be in contact with the court officer. Be in contact with the court officer. Let the record come first. Thereafter, whatever under which head the matter will come up, it will come
Lordship,
up.
if it is reconstruct, then it will be. I mean, otherwise, it will not be repaired.
Learned counsel, why the question of reconstruction comes now? That's a far-fetched effect about reconstruction. Let it be requisition first. Thereafter, we will see what the fate will be.
My lord, may I beg to submit before your lordship in connection with the second appeal, my lord. In this matter, paper book has been filed. I am for the respondent. At my cost.
There is no application pending.
No application is pending,
Ready
and the
for
notice.
Paper books.
Paper book has been filed. I have
For the
served
appellant.
notice. I am for the respondent. My lord. At my cost, I have prepared paper book out of court. My lord, let it appear as marked for hearing.
Intimated upon the learned.
Yes. Upon notice, I am mentioning.
Mhm.
And in fact, my lord, may I submit further that the Honorable Justice Dinesh Sharma was pleased to direct.
Learned counsel, what is taking place in
No, it was
other
due
bench,
to, it was,
let that chapter be not disclosed
It-
here. Will come up
No.
at the time of hearing.
it was directed that the matter would appear in the combined list of December. That's why I am mentioning. But it did not appear.
Combined list of December of that bench.
No, not of that bench, any bench,
How
having determination to deal with the second appeal matter.
Learned counsel, you are senior counsel. How can one bench direct that it will appear under the heading under the combined list?
Now, kindly have a look at the order, my lord. Then
No, no,
kindly have a look at the
no need
order,
of- no
and
need of-
not in the particular
going to
bench.
no need of going to that order.
My lord,
You have filed the mentioning slip.
Yes,
Let the record be requisitioned.
yes,
After arrival of the record, be in contact with the court officer.
my lord,
It will be under the heading to be
For-
mentioned.
my lord.
my lord, 28th of November, your lordship, after hearing both the sides, my lord, was pleased to fix the matter to appear on today.
Mm.
It's not appearing.
Not appearing. List থেকে
Your lordship,
বেরিয়ে যাবে কি
kindly
করে?
recollect
List থেকে বেরিয়ে যাবে কেন?
city number. That is
City
why your
number.
lordship was pleased to direct that it should be sent back, and within 3 weeks it should be taken back or brought back here with regular second table number, SN number. Because it is with T,
Was there any order
that part not.
from the
no order.
department?
That part no order.
দেখে নেব।
Yes,
Available.
subject to record come.
First of all, the
Subject
record
to-
be available. Yes.
My lord, may I be permitted to mention before your lordship,
Hmm.
one stay application has been pending to adjudicate before your lordship
Hmm.
in connection with the second appeal 72 of
When it has
2024.
been admitted,
It is admitted in the year of 2020-24.
have you intimated the?
Yes,
Is
my lord, my lord.
the
Annex the,
record available now?
no, there is no, record is not available, my lord.
You are the
Sorry, appellant.
appellant what, landlord or anything else?
Appellant for landlord, my lord.
Appellant landlord.
Yes.
Decreed or dismissed?
No, decreed.
Decreed, thereafter reversed
Yes,
by the first appellate court.
yes.
Where's no. Where's the intimation to the other side?
Yes, already annexed, my lord. Grateful, my
To mention, my lord, one application, connection with the second application, my lord, three application has been filed by the other side. I am appealing to the respondent.
Hmm.
And with regard to the one is, my lord, the restoration, another is, my lord, taking aside of the abatement, and another is the section five.
Hmm.
My lord, the notice has been sought, my lord, Mr. Speech is not regularly available. So I have sought the notice by the post.
All the applications have been filed by you,
Filed by the, my lord, the appellate.
appellant.
That has to be hard. It's pending for 2017.
Matters may be pending. Whether it is pending before this bench, if it is pending before this bench, then you mention that it is pending since 2000
No, no,
or
it's
2000 or 1999. Have you intimated the other side? Requisition করুন।
three applications.
3 applications prior to admission,
No, after admitting this appeal.
after admission.
Right.
Expiry
Expiry, my lord, the.
prior to admission. So
So, my lord, the, since it is not.
let the matter appear requisition for. The matters which are being mentioned, all will come up under the heading to be mentioned first.
Including my one, that was, hearing was going on.
Each and every matter. Document.
Item number 1.
Milord, item number 1, Milord. I am appealing for the respondent on the
First
joint
time for the first time.
first time, Milord. It was hard, Milord, at length before my Lord Mr.
By this
just
page.
before my Lord Mr. is shown.
Lord Councils,
It has to be
Please,
handed out
please
from the beginning.
be kind enough
Your
not
Honor.
to narrate about what has taken place earlier.
Your Lordship may kindly fix, Milord,
This is the
anything.
first time it is appearing before this bench. 1989.
My lord,
Suit for
Suit for eviction on the ground of
eviction.
subletting.
subletting.
Both the courts we have won. We are the landlord, Milord, they are the tenant.
but I am for the appellant, my lord, Mr. Sagar Bandar, the senior police is appealing on behalf
So,
of the appellant, my lord.
When?
But,
Coming Friday.
my lord, may it be after.
No.
My lord, it will take at least 3 days, my lord. My lord,
Subletting.
my lord,
And it
there are,
will take 3 days. No.
yes,
not
my
at
lord,
all.
there are some point. There is an application was also pending before your honor.
No,
Coming
that has to
Friday.
be heard along with
My
this.
lord, Mr. Bandyopadhyay has requested that the matter may be taken up after vacation, my lord.
So on second
Second
of January.
Second, I think second will be dicey.
Milord,
Second will,
No, second, let-
হয়তো ছুটি হতে পারে।
let us, Milord, give it a try, Milord. If it is not happening, Milord, then next
Monthly
Friday.
list of January 5th.
No, Milord, a monthly list it will. Lordship, let us, Milord, Milord, come back on second, Milord. Let us give it a try, Milord. Milord, okay, substitute image. Yes, Milord, long name. BT Banerjee and others, Milord. BT Banerjee is, Milord, I'll just. Daughter.
When he has been substituted. Wide order dated.
Milord, data বলুন। না, না।
Can 4760, I think.
No, that is for bringing on record the subsequent events.
That has been filed by the.
Order 41/27.
Yes, Milord, that Milord, already order passed. That will be heard along with the appeal hearing.
From the order book, it transpires that all the orders reflect can 1 of 1997, old can number 5597 of 1997.
5597. Pending. Can 4760 of no, can one pending? Man. Can 3 mil
Can 2 is pending.
can 2 millard is pending 4760. June's order 2024.
4760 affidavit in opposition, affidavit in reply. Into 4760 টা কত?
Out on 1st of December 2023.
I have found one 4760 old number 4760.
Yes, Milord, that is can 2, Milord, which is pending. Can 3 is for substitution, already disposed of.
Be granted to produce the documents referred.
This is pending one.
So, order 4127,
Yes, one.
Yes.
if
that-
it is so. it
Yes,
will be
yes,
taken up
Milord.
along with the.
Milord, that is the order, Milord.
That is already observed by the.
Milord, your lordship will get the order,
In which
Milord.
paragraph? In which paragraph it is mentioned? Additional documents?
That is filed
Third
by,
council.
Milord, I am just giving it.
এই যে additional শিক্ষকদের মধ্যে আছে। এটা মেমো করা হবে। না না এটাই এই তো 4760
9 onwards.
মালার প্যারাগ্রাফ
9 onwards.
Nine.
The agreement.
991 yes
Is it so?
Milord,
It is your brief.
yes that's same
You will have to assert.
Milord, Milord, we have,
Actually,
Milord, this matter, Milord, lordship kindly sees, Milord, this application came up for hearing, and Milord, this honorable court passed an order. This application will be heard along with Milord at the time of final hearing.
Yes, it will be heard.
So, Milord,
Order 4127,
yes,
no separate hearing. It will be
Well,
heard.
para 8 and para 9 para 8
আচ্ছা, দাঁড়ান, আর
is relevant
দাঁড়ান, PM2 হচ্ছে old number
4760, lordship.
একটা টাকাই হোক। আর can 1
Milord, can 1, Milord, is already disposed of,
or
if I am not
disposed of
wrong.
wide order.
Milord, wide order, এটা হচ্ছে can 3.
ওরে গন্ডগোল হবে আবার। হ্যাঁ, can 2 তো হলো, can 3
Long ago, because 89 this appeal was admitted.
বুঝতে পারছি, কিন্তু এখানে তো মানে অর্ডার শিটে থাকতে হবে। From the order dated 1st of December
Yes,
2023
can 3 was disposed of.
transpires that this is an application for substitution.
Yes,
Can 3.
that was disposed of, 3 appellants were
It is directed
substituted.
to make out the necessary correction. So can 3 substitution disposed of.
Lordship.
Right order dated. It will not mean can 3 of 2020 এটা order টা হচ্ছে না কিন্তু নোটটা can 3 of 2007 old number 2465 or 2000 can 1 of
But-
1997
But can 1 I don't have, I'll just see, the compilation if I have.
in the record 2465 is available and 2465
Can 1 is 5597 of 1997.
that is not in the record.
No, 2464. ওটা pending আছে 2460. 4760 ওটা pending এইটা। এটাও pending, এটাও disposed of substitution, এইটা হচ্ছে canvas।
Actually,
Yes, sir, my lord. The,
whatever it might be, but it should be in the record.
but there is no.
The order,
The order
your lordship has got, the initial order of admission, in 1997. That order, probably can clarify. That is also with the paper book,
actually order গুলো না order গুলো actually in the paper book.
It's not a paper book, my lord. This
No,
is a
it is-
compilation prepared by me.
compilation
Paper
because-
book is
No, no.
something different. Paper book is very old.
No, it will be in the paper book. The second appeal paper book, contains, the order of admission.
This is paper book, I think.
ওর মধ্যে থাকবে দাদা।
Paper book.
My lord, this is a compilation has been prepared by me after obtaining
has
the
been mentioned.
certified copy.
Nothing has been mentioned whether it is a compilation or what sort of thing is this.
Actually, documents I have obtained,
Hmm.
previous bench has asked for that documents. এটা থাকবে, এটা চাইবে।
Page 24 of the paper book, the initial order.
এই এতে নেই, দেখি দিন।
আপনি পুরোনো অর্ডারের রেকর্ডটা দিন না। পুরোনো অর্ডারটা একদম পুরোনো ইনিশিয়াল।
Milord, this is the paper book. Milord,
শুনুন শুনুন এদিকে শুনুন, পেপার বুকটা বার করুন।
Milord, this is the paper book. Your Lordship may kindly see, Milord, page 24.
ওখানে আছে? আচ্ছা থাকতেই হবে না 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 আমাদের এখানে থাকবে তো রেকর্ডের সাথে পাতলা 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 পেপার বুক হবে।
Second,
কম্পাইল
from the order sheet dated, Milord, 24th of February 1989, that initial application was placed for hearing after 2 weeks of admission. তারপরে আর কোনো কাজ পাওয়া যাচ্ছে না।
there was an injunction application. Let the application for injunction be
Yes.
heard on notice and affidavit of service be filed. There will be arbitrary stay of execution of the decree until further order. This is the stay application.
Milord, the injunction order probably has become infructuous because injunction not to execute, because we, Milord, filed execution case by that time. So, Milord, the honorable judge, Milord, passed an order of stay.
Let that application, let a copy of that application be provided at least. Can
আচ্ছা,
1 of 1997.
মনটা আছে।
আমি পাইনি। A record during the course of this day, and thereafter apprise this court on the next day.
Lord,
On going through the record, on going through the record, going through the record, it transpires. Wide order dated 1/12/2023, it is mentioned there. The can 1 of 1997, not here. Actually, can 1
no, Milord,
is not with us, both of us. We couldn't find this can 1.
can one probably disposed of. That is why, Milord, it is not here. It is not there,
For
Milord.
the sake of convenience, let us take that it is disposed of. There should be an order. Where is that order? That
Milord,
it
the
is-
order sheet, bunch of order sheet must be there, Milord. Milord, may I just
For
have,
that reason, go through the record. Both of you go through the record. After going through the record, it transpires that number can 5597 of 1997 is not in the record. Full stop. In such circumstance, the learned counsels representing the appellant and the respondents are requested to furnish a copy of the same on the next day. Full stop.
can one?
Paragraph. Order 41. এবার হচ্ছে can next হচ্ছে can 2 of 2022. প্রথমে হেডিং দেবেন can 1 of 2022. এত বড় কথা দ্বিতীয় হচ্ছে can 2 of 2002. This is an application seeking leave to provide additional evidence. Full stop. On consent of both sides. Let the on consent of both sides government as the said application is for additional evidence. The matter will be taken up along with the hearing. Can 2. Now can the old number can 2 of 2002 এর old number 4760 of 2002. এবার আসছে can 3 of 2007 লিখে দিন নাহলে পরে গন্ডগোল হয়। যেটা প্রত্যেকটা অর্ডারে দেখা যাচ্ছে। Can 3 of 2007 corresponding to old can number 2465 of 2007 was an application seeking substitution of the sole respondent. Full stop. The said application has been disposed of and the legal heirs of the respondent have been substituted, who are already on record now. Full stop. As such, the said application has been disposed of earlier. Where was it? As such, let the matter of the paragraph, let the matter appear under the heading. Oh. So the paperwork is also there. According to you, that is the paper book. And a compilation of documents.
Compilation of documents has been filed.
No further documents are required.
No.
So let the matter appear under the heading hearing on 2nd of January 2026.
Better already 5th of January, 7th of, 9th of January.
It can be kept on 3rd or 4th of January,
3rd of January, Lord.
Saturday. So 2nd of January.
Look.
And in the meantime, both of you go
Well, I'll
through the
just go through Lord,
entire record
if I find the
and
order sheet.
provide the copy of the application, which application which is pending. That phone application pending is what?
Can one,
Lord, if it is disposed of, Lord, then Lord, everything will
very
be.
difficult because
Which one disposed?
Lord, can one, if it is disposed of long ago, Lord, then.
Then you show the
Well,
from the
Lord,
order
I'll
sheet
next day, Lord, I'll show.
from the order sheet to show that
Well,
it has been disposed of. Then there's no
Or
question
Lord,
of-
we can Lord, check the case status because case status would show Lord, whether can one is pending on.
from the order sheet.
Well.
Next.
Good.
item number 2.
Lordship, item number 2, I am for the defendant respondent, Lordship.
I'm for the appealing.
Lordship, in this matter, one substitution application has been filed, Lordship. The original appellant has died on 14 April, Lordship, 2025. And his wife and his son, will be substituted. Can 3, Lordship. Paragraph 3. Can 3, paragraph 3.
Can 3.
Can 3.
Lordship.
But in the cause list, it has been listed. Lordship.
Record গুলো এলে না
Lordship. The appellant appellant died on say 14 April 2025, leaving behind his wife at paragraph 3.
Paragraph
3, Lordship.
you are representing
Appellant
Appealing, Lordship.
and you are representing the respondent.
respondent. It is his her application. Lordship.
That's why the query from this end. You are submitting and she is not submitting. Nandolal Kurmi
Kurmi, Lordship.
expired on
14th of April 2025. His wife and his son, Lordship.
Haya Kurmi and Vishwajit Kurmi
Lordship.
within time.
Lordship.
Background.
As regards to the other applications, can 1 and can
Can 1 stay application and can 2 is a section 5
Section 5.
application.
section 5.
Lordship.
There is a delay.
How many days delay?
400, 300 something. 300 something. 640.
Let us first of all take up the Can 3 of 2025. Can 3 of 2025. The said through the said application, the wife and son of the original appellant, namely Nandalal Kurmi, who has expired on 14th of May, 14th of
14th
April,
of April.
April 2025, has sought to be substituted. Apart from these two persons, there are no other heirs.
Lordship.
Full stop. The said application seeking substitution has been filed within time. Full stop. As such, let the wife, namely Chaya CHHAYH, Chaya Kurmi, wife, and Vishwajit Kurmi, the son, be substituted in place of the original appellant, namely Nandalal Kurmi. Full stop. Department to the needful. Acha, the leading Can 3 of 2025 is disposed of. Deloitte Council representing the respondent or respondents.
Respondent.
Respondent also admits that the application is within time and as such does not raise any objection. Full stop. এখানে insert করে দেবো। Now can 2. Oh, can 2 is
Can do is section
Section
5
5
application.
section 5 application.
নিশ্চয়।
Yes, 642 days.
642 days, Your Lordship. We have filed an opposition, Your Lordship, and we want to
Your
file an no file the
Filed.
reply to the supplementary affidavit, Your Lordship.
Supplementary.
Because the
Yes,
to
affidavit
the
of
application
opposition is here.
section 5.
1 minute. Affidavit of opposition is here.
Also, we have filed an
Supplementary process. When the supplementary affidavit has been filed.
26th February.
26th February 2025. To the supplementary affidavit.
Nin.
দাদা
Nin.
Lordship, my humble Your Prayer Lordship, kindly keep the section 5 application on next date, Your Lordship, because his senior Shivaji Kumar has requested us to Your Lordship kindly.
Who's senior?
My
Yes,
senior.
yes, her senior, Your Lordship.
Need not give your name. Let their names be there. You have to submit. Can 3 টা হয়ে গেল dispose of it. এবার হচ্ছে have you served copy
Yes, Lordship. I have submitted.
of affidavit in opposition or reply reply to the supplementary affidavit in respect of Can 2 of 2024, wherein the appellant has sought for admitting the, sorry, sought for condoning the delay in filing the appeal, condoning the delay of
42 days.
642 days in filing the appeal. It's been filed, copy has been served, let the said, let the reply to the supplementary affidavit be kept with the record, full stop. Paragraph, the learned counsel represent, the learned advocate representing the appellant seeks an accommodation for this day in the ground of his senior. Let the matter appear for hearing of the said application, being can
Two.
two can
Two, Lordship.
two.
Yes, Lordship. Can one is a stay application.
Lordship.
Been
Yes. Yes, Lordship. Can 2 of 2024.
I could see can one of 20
No,
minutes?
so, can 1 is a stay. Your Lordship. First can 2, your Lordship.
Why have you mentioned in the matter of can 1 of 2024? Both have been mentioned, can 2 and can what one? Next Friday,
Lordship.
Next Friday.
Friday.
next Friday, 19th of December. এখানে খণ্ডন হবে, ওখানে চলে যাবে।
Item number 3.
The appellant.
Lordship,
This is section 5 application.
Section 5 application.
This matter was under heading of application previously, but today I don't know the reason why the matter appeared under 2 units.
This is for the first time these matters have come up before this bench.
It was running in the list, but not.
Running in
Yes, previously it
list
was.
of this bench.
Yes. This was running. There are 2 matters. We mentioned 2 matters, but only one is appeal. There another appeal is SAT 214, and before your lordship SAT 213. So what happened? We since there was a caveat, we served the copy of the application and memorandum upon the advocate for the caveator.
Suit for
Eviction.
suit for eviction. Only suit for eviction
Eviction
by the landlord.
on the ground of building rebuilding.
There was no suit by the tenant as regards to declaration or injunction.
No.
So it has been decreed.
Decreed by the.
Decreed.
lodged in both the courts, your lordship. It's a second appeal, subject to your lordship kind consideration.
Learned counsel.
Lordship.
At least this is known.
Certainly.
Affirmed by the first appellate court. Now, why?
Not total affirm. Court be trial
No,
trial court below.
The question from this end is why 2 appeals? 2 or 213, and you are also referring to 214. Why 2 appeals?
Because
214 has also been filed by you. By the self
yes,
appellant.
there are two different grounds. There are 2 different grounds. For that reason.
For that reason, 2 appeals.
Yes.
Huh?
Yes. It is required. Otherwise, my lord.
May I assist your lordship?
My lord, today we are before your lordships for condemnation of delay. And my lord, kindly have a look. The trial court.
No. Let that issue be cleared.
The trial court decreed the suit by not providing the relief under 7(4). At the same time, the learned trial judge as well as the subordinate appeal,
First appellate.
subordinate appellate court held the rent was paid continuously. No specification. It is more fully described that rent was paid month by month.
Whatever may be,
Yes.
whatever may be. Will there be two appeals? One will be heard by this bench and the other one by another bench.
There is reason, my lord, there is reason. My lord, there is reason because rebuilding in one hand, the relief.
Counsel,
My lord, kindly see my lord ordering portion.
suit property,
My lord,
suit property in both the cases, both the appeals. Suit properties,
same and single,
Same.
same and single,
suit property.
same and single. One room. My lord, kindly have a look. In one hand, the court is, my lord, refusing relief
I've got
under
it,
7(4),
got it.
and another hand directing the decree holder to complete the building 2 years. 2 years.
Hmm.
2 years. So that is like a suit has not been the 7(4) relief must be provided. If
Now,
the suit is decreed on any other ground, then the direction under section 11 does not arise.
Lord Counsel,
My lord, there is a requirement is this, my lord.
is it not required that both these appeals be taken up together?
Yes. No problem. For that reason,
That
at
will
first I
submit
submitted before your lordship. There are 2 appeals.
Give the number of the
With
other
first,
appeal.
214. This is before your lordship 230.
Kind enough to
এই
give in
এই
writing.
লিখে দিন
শুনুন, এই যেটা নাম্বারটা দিচ্ছি, এই নাম্বারটা রিকুইজিশন করবেন। সেকেন্ড
25
25 ওনারা লিখিত দিচ্ছেন, ঠিক আছে, ওটা নেবেন।
আমার মেনশন স্লিপ দেওয়া ছিল কিন্তু
Any other thing apart from this one?
Let's say, may I subject to lots of card consideration, which I was wondering whether I would like to submit. So it's a second appeal. As I understand, earlier it was admitted, it ought to be admitted before the division bench.
Yes.
It was my understanding.
this is not
It
for
has to be
admission. This section 5 issue.
In that one, 214,
That is same.
section, there's
Section 5, yes. There is
Second
little delay.
Second.
section 5.
My learned friend.
In this one also,
Yes.
can one, how many days delay?
My lord, delay is about not
As I seen
much,
6
no.
days.
Very
5 to 6
minimum.
days. 5 to 6 days.
Very minimum.
5
5 days. 5 days.
5 to 6 days.
For that
Yes,
reason,
see.
That one,
same.
same. The learned counsel representing the appellant
Admission এর জন্য নয়।
ঠিক আছে। Right.
submits that
Exactly.
submits that there's another application. Sorry, there's another appeal being number SAT
SAT
214 of
25.
25.
2025.
25 ওটা স্লিপটা দিন 4 লিখে দিয়েছি 25 চেক করে না
check করে নিন। দেখে নেবেন 2025 214 of 2025 কি হলো?
আইটেম নাম্বার কেটে লিখে দাও না
There's another appeal being number SAT 214 of 2025 in respect of the same same suit property
হ্যাঁ
and
এটা
arising out of the same judgment passed by the first appellate court.
yes first appellate court being title appeal number
Which one
82
would you like to prefer?
My lord?
Which one would you like to prefer? Or advice or hearing from
no
this?
your lordship's dictum
No, not dictum. Everything is request from this end.
yes
A judgment passed by
learned 12 bench 6th bench fifth bench City Civil Court Calcutta being title appeal number 82 of 2019
learned fifth bench City Civil Court, Calcutta, dated 30/6/2025. 30/06/2025. This was as both the appeals being number 213 of 2025 and 214 of 2025 SAT level, 214 of 2025 are arising out of the self-same judgment mentioned above. As such, both the second appeals are required to be heard together. In such circumstance, let the record of SAT 214 of 2025 be brought to this bench. এটা এই রেকর্ডটা রিকুইজিশন করে আনিয়ে নেবেন, ঠিক আছে?
Let's say appellant of can 1 and memorandum of appeal, only section 5 has been served. Only.
এবার প্যারাগ্রাফ করুন। The learned counsel representing the respondents submits that only the memorandum or copy of the memorandum of appeal,
Only the delay application has been served.
only the
Yes, এই তো আমার সামনে। এই তো দেখুন, এই যে আর এই। এই তো আপনার সামনেই, আপনার সামনে।
তো ঠিক
এটা
আছে,
হয় কোনো
ঠিক আছে, ঠিক আছে, দিয়ে দেবো।
only the application seeking condonation of delay, that is CAN 1 of 2025 in respect of SAT 213 of 2025 has been served upon
both 214 as well also. Only section.
তাহলে সেন্টেন্স আবার পড়ুন। Condonation of delay in respect of both the second appeals have been served upon the respondents. Apart from that, neither the memorandum of appeal, neither the copy of the memorandum of appeal, nor the copy of the stay application.
Lordship. As I understand, they have filed. Can 1,
Let
can
me-
2.
Stay is
Let-
not business of this.
Let it be admitted first.
Let the memorandum appeal be served at least.
ওটারও দরকার হয় না।
Are you entitled now?
Because
Have to be
memorandum
filed.
appeal, I am entitled, Lordship.
No.
Not stay, but
No.
subject to a Lordship kind consideration.
No,
If required, that will be directed by the Honorable Division Bench.
I leave it to your Lordship.
and usually first time we at the time of
দরকার নেই।
handing over paper book.
এটা দরকার নেই, ঠিক আছে? হলো? Anything, any other? Um, um, let both the appeals being paragraph, let both the appeals being SAT 213 of 2025 and 214 of 2025 appear together after the arrival of the second appeal being number, record of the second appeal being number 214 of 2025. After the arrival of the
My lord.
record of that record, it will be under the same heading. It will come up under the same heading to be
We mentioned.
thereafter
My lord,
application.
my lord, no problem.
Please.
My lord,
The-
my lord,
The matters are placed under the heading to be mentioned to set right the record.
my lord. My lord, one thing, my lord, there are item number 49, that is CO, civil division case. I heard that that today, my lord, your lordships, my lord,
Yes, till one.
till,
If, but if time permits,
yes,
then after the division bench with Honorable Justice Mantha, once again.
because there urgency, I am suffering blanket order of stay. I got the decree.
What can be done?
My lord.
The matter will come up.
I come at 1. if your lordship comes serially,
Learned counsel, all the matters will be taken up serially.
my
All
lord,
the matters will be coming up serially. What is the number?
49.
49. So it is. Hmm. It is third one,
Yes,
third
yes.
civil revision.
Yes.
It will
I
come.
don't want any preference, but
That is
if
that is the thing.
possible,
That is the thing. If one is preferred, then
no, no,
one
no,
will be the other
certainly not,
preferred.
certainly not,
Matters
certainly
will
not,
be taken up.
my lord.
With your lordship.
Next.
Item number 5.
My lord, I am for the respondent, my lord.
বাইরে ডিসপ্লে হচ্ছে none is yes.
I am for the respondent, my lord. My lord, earlier occasion they want to file the wakalatnama, my lord. My lord have give time them to get no objection from previous advocate.
None is representing the appellant. And there is nobody to seek accommodation in this regard. Let the matter go out of the list.
Much yes.
এটা যে লিস্ট থেকে বেরিয়ে যাবে। যখন একটা ম্যাটার ধরা হবে তখন নেক্সট ম্যাটারটা রেডি।
Having the brief matter.
You start. I'm providing the record. You start.
My lord, there are substitution application along with section 5, my lord. My lord, first of all, in 2019, it was filed, and thereafter 2014, same pair, as because the property belonged to the wife, and after the death of the
It has not been admitted.
it has not been admitted, my lord. 2019 section can 1 and 2, and 2024 1 and 2.
It has not been admitted.
Admitted, my lord.
So, void order dated.
My lord, I am not having the brief, my lord, for that difficulty, my lord. Just suddenly come up, so guys.
It is most unfortunate. It is most unfortunate that the learned advocate representing the appellant is seeking an accommodation for this day, as because he is not having the brief. Let the matter appear on 19th.
Right.
The next day, no
My lord.
accommodation will be provided on
My-
whatsoever ground. Next.
Number 9, 8.
Item number 8. And I am for the appellant.
I am appealing on the respond number 8A to 8D.
I am
On 14th of November. And today, None is representing the respondents number 2 to 5. Mrs. Shoini Chakraborty,
She's
representing.
on her legs in court number of 13, your lordship. She'll be coming, your
She will
lordship.
be coming. And Shehnaz Tarek Mina for respondents number 6 and 7.
He's,
So,
he is in court number 551, your lordship.
so you are in the same boat.
Yes, your lordship.
Let us comment.
My lord, I'm commencing this argument, my lord.
First of all,
But
paper book. Paper book.
My lord,
Paper book.
my lord, I may not complete it today because, my
Yes.
lord, I have been
That is not the fact. That is not the fact.
day before yesterday, my lord, I have been briefed, so my lord, I could not prepare myself thoroughly, my lord.
But, this from this end, the last part of the sentence is being objected. First part is okay. You may not complete, but as regards to preparation, one has to come prepared.
No,
Let us start.
yes, my lord. Let us. My lord, this is a suit for partition under the Mohammedan law. My lord.
Yes.
Well,
Genealogy required.
my lord,
Genealogy required.
genealogy required.
Have you? Do you have a?
But
Okay.
today I have
On the next day you provide.
my lord,
Provide the genealogy.
yes.
Let us.
My lord,
note
this
of-
is a suit for partition, declaration, and permanent injunction. My lord, the defendant is the appellant before your lordship. My lord, rather the heirs of the defendants, original defendants, are the appellant before your lordship. My lord, one Sheikh Ahmed Hussain was the original owner of this property.
Plan to the record the name.
Lord, your lordship has been muted. Lord, we can't hear your
Property. My lord, this is a Thika tenanted property. My lord, she was the original owner of the structure.
Thika property.
Yes, my lord.
Hmm.
Now, my lord, Sheikh Ahmed Hussain was the original owner. He expired on 17th June 1933.
Expired on
17th June 1933. Leaving behind his widow Ajijan Bewa.
Ajijan Bewa.
Ajijan Bewa, his widow. 3 daughters. My lord, the eldest one is Hasina.
Mr. Chakraborty, do you have a genealogy?
I
It was
have.
expected that You will provide.
Lordship, we shall. I have it in
You will
handwriting.
provide. On the next day,
I shall provide. I shall provide.
widow.
Yes, widow
And
Ajijan Bewa,
Three daughters.
3 daughters. The eldest
Son,
one is
no son.
son. Son is there.
Achha,
Hasina was the eldest one.
achha.
Then Jarina.
These names are required.
Yes, yes, it's required.
Hasina,
Yes,
Jarina,
Jarina. Then the son Abdul Karim and Meher Afroz, the daughter.
you said the three daughters.
3 daughters: Hasina, Jarina, and Meher Afroz.
Oh, last one. The son, the name of the son?
Abdul Karim.
Abdul. Sole son.
Sole son.
And
And the fourth one is
the name of the-
Meher Afroz.
Meher.
Meher. Meher Afroz.
Achha. Yes.
And after the death of then I am placing before you is the plaint case.
Yes.
What has been stated in the plaint. And the plaintiffs are the heirs of Abdul Karim.
Achha, Abdul Karim.
Yes. And the appellant before your lordship is
Achha, so the sole son.
yes.
Huh.
And the appellant before your lordship is the heirs of Hasina. The defendant number 1.
D1, daughter number 1.
Yes.
Hasina. Other defendants.
Other Jarina was the defendant number 2.
Legal heirs of Hasina.
Hasina, the appellants before your lordship.
So, Hasina appellant, legal heirs of Hasina appellants, and the legal heirs of Abdul.
Abdul are the plaintiffs, respondents.
Plaintiffs, respondents, yes. Apart from that,
Apart from then, Jarina was the defendant number 2.
defendant number 2. Herein,
Herein, my lord, he is Jarina's Jarina यार कहाँ रही? Jarina was the defendant number 2. Number 6, 7, 8. After the death of respondent number 8, his heirs are there, 8A to 8D.
Farida and Sajida, Shagufta and Farha.
My lord.
These persons are
the heirs of Jarina.
Achha.
Jarina came from Ahmad Hussain.
Who is
Mr.
I am appearing, Milord, on behalf of respondent numbers 2 to 5.
respondents number 2 to 5?
Hmm.
Achha. Being assisted by Mrs. Chakraborty?
Yes, Milord. Mrs. Chakraborty is probably for 1 and I am for 2 to 5.
No, for respondent number 1 is Progyani Das.
No, Mr. Chakraborty Milord is with me, there's no problem.
The defendant, 1 minute, Jarina was the defendant number 2. And now herein, the legal heirs of respondent number 8.
8.
Who are the respondents number?
From 6 to 8. From 6 to 8.
Respondents number 6 to 8.
Now, after the death of Ahmed, the original owner, the property was recorded in the name of Ajijan, the widow, by a registered deed of lease dated 8 September 1936.
Only in the name of Ajijan?
Only in the name of Ajijan, the widow.
Deed of lease dated
8 September 1936.
8 September 1936.
My lord.
In the name of Ajijan.
Ajijan Bewa, the widow, expired on 31st October 1944.
Date 30th October?
31st October 1944.
31st October 1944. Yes.
44. And it is alleged in the plaint that at the time of death of Ajijan Bewa, Abdul Karim, the son, was 14 years old.
Achha, he was minor.
He was minor.
As has been alleged in the plaint. Which you are admitting?
No, I am not admitting.
Yes.
Then, at the time of death of Ajijan Bewa, Hasina, my predecessor, was the only adult married members.
Who was the adult married member?
My client's predecessors, Hasina.
And what about Jarina?
I am coming, Malay.
Achha.
Now, at the time of death of Ajijan Bewa, Meher Afroz, it is said that Meher Afroz left India and settled at Bangladesh, and she expired there. Now, it is stated in the plaint that before the death of Meher Afroz in 1946,
she expired in
the
the year
date of expiry.
Date not known, but year is within your knowledge.
No, it is alleged that before she left for Bangladesh, she, by oral heba, gifted her share in favor of Hasina, Jarina, and Abdul Karim.
So you have also received.
My lord?
So you have also received.
Yes.
So I don't think there is dispute as that deed of gift. Is there a dispute?
My lord, I shall, my lord, I shall submit before the
As regards to
lord.
share.
Yes. No, my lord. It is stated that
one minute. This Ajijan expired in the year
1944.
1944, and Meher left India
In sometime in 1946, because before that,
in the year 1946 she expired.
no, not expired. The date of expiry is not known to us, at least not known to me.
No, in the plain it is not. Oh, she left India in the year
Left India
1946.
sometime in 1946, and before that,
अच्छा, अन्य. अच्छा. According to the plaint, this Abdul
Abdul Karim,
who is the plaintiff also.
yes,
He was 14 years at the time of death of Ajijan,
yes,
and Ajijan expired in the year
1944.
So, Meher was also minor at that relevant point of time.
My lord. Meher was also minor.
This deed of gift, hiba,
Oral.
oral hiba. When it took place?
Sometime in 1946.
Prior to her leaving India.
Yes. By such oral hiba of Abdul, Meher approach, Hasina got 1/4,
Hasina 1/4,
Jarina 1/4,
and Abdul 2/4, half.
Abdul half. It is according to
According to
Mohammedan law. No. Now, Malad, it is stated, Malad, that
1 minute, 1 minute. Hasina and Jarina. Yes.
no, Malad, since I am Malad, placing before you on
You have expressed that you have a question mark as regards to the hiba.
my lord.
What is the question mark? You
Question.
have obtained half.
Malad, I shall Malad proceed further, then Malad, I will be answering your lordship's query, Malad. Now, Malad, it is stated that upon receipt of a letter from my learned advocate, Malad, the plaintiff number 4 first came to know about the deed of sale. My contention is this, that Abdul Karim on 27 July 1946 sold the property which he got from his father Ahmed Hussain to Hasina Jarina.
According to you,
According to me, my lord,
sold
Hasina,
his entire property.
Abdul Karim's entire property, Jarina's property, and Meherapro's property. All the three co-sharers, my lord, sold the property to me.
According to you, whatever property which he has acquired by way of inheritance and by way of hiba, oral hiba, he transferred to
Not only Abdul Karim, Jarina and Meher Afroz also transferred. On
Meher Afroz does not come in the picture. She has
no, my
left.
lord, she left in 1946, but my lord, the deed which was executed in favor of my client, it was on 27 July 1946. So, my lord, if Meher Afroz, my lord, departed.
Now the question is, Meher Afroz, according to you, you have purchased the entire share of Meher Afroz.
My lord.
And according to them,
Then Meher Afroz before leaving the
gifted 1/4,
1/4, and half
Hasina and Jarina.
Hasina, Jarina, and Malad Abdul Karim, the brother.
Synopsis is required.
Very much required, Malad. I must be Malad candid before it is very much required.
The bone of contention might be small one, but synopsis of the entire fact.
Yes.
Abdul purchased the entire of Meher and
not Abdul not purchased. Meher approach Malad by oral Gheva gifted the property to Hasina, Jarina, and Abdul.
Thereafter, you said
it's my case. That Abdul Karim, Jarina, and Meher, the accepting my client, Jarina, Meher, and Abdul, the two sisters and the brothers.
Jarina, Abdul, and Meher sold their property to Hasina.
In 1946, 27 July 1946. By a deed, registered deed.
According to you, you have purchased from through a registered deed of sale from Jarina, Abdul, and Meher.
My lord.
The dated
27 July 1946.
27th July 1946.
Now, my lord, plain case is this, that since I have tried to evict the plaintiffs, but the original plaintiffs, and sent a notice of eviction under section 6(4). Now, my lord, the plaintiffs came to know for the first time that I am claiming as the full owner of the property. So, my lord, they inquired about the deed and, my lord, obtained a certified copy of the deed, and thereafter they filed this suit.
Notice of eviction dated?
Notice of eviction date kore? 1 minute time for me, your lordship. The notice. There is nothing stated in the notice, but my lord, I shall inquire my lord in my lord, communicating my lord, my lord. Only in the plaint, my lord, it is stated that the recently the plaintiff number 4. No, no, my lord. Now, my lord, it is contention of the plaintiffs, my lord, that in 1946, Abdul Karim was 16 years old.
Yes.
So, my lord, he has no capacity to transfer the property.
It is mentioned wherein? In the plaint.
In the plaint. My lord,
Abdul is the plaintiff. Abdul is the plaintiff.
Abdul is the plaintiff. So, Abdul Karim.
And he has mentioned in the plaint. And in the plaint, he has mentioned that he was aged 16 years.
Yes, Abdul's legal heirs, my lord, filed the suit and contained that the Abdul Karim has not transferred the property to Hasina because Abdul Karim has no right to transfer at the age of 16.
The capacity to transfer at the relevant point of time.
Yes, yes. And my lord, then my lord claim that half share of.
Everybody will be given the requisite opportunity.
Then my lord claim for partition.
And let him place his case. That's why I didn't interrupt my
And my lord, then my lord, they filed this case suit for partition of half share of Abdul Karim. My lord, half share of Abdul Karim. He got the property from his father by way of inheritance, and my lord, from Meher Afroz, what he has got together, it comes to half share of the property. That's the my lord suit. And my lord, defendant's contention I have already my lord, placed.
So according to Abdul, he has acquired through inheritance and purchase half share of the property.
Half share of the property. Now, my lord, my contention, my lord, I have already, my lord, submitted before your lordship that by way of deed of sale, this Abdul Karim, Meher and Jarina sold the property to me on 27th July 1946, and I am the absolute owner of the property. That is my contention. Then, my lord, the suit was filed, and my lord, the suit was decreed according to the share, my lord, that half share is of the plaintiffs, and my lord, other share has already been declared, my lord, that is 1/4 share with regard to the premises is of defendant number 1.
So preliminary decree by the trial court was
on, my lord,
Abdul half.
Abdul half.
And
my lord, the Jarina, I'm saying defendant number 1, my lord, Hasina's heirs 1/4.
And Jarina 1/4.
1/4. And my lord, that has been affirmed by the landed judge in the lower appellate court.
First appellate court.
First appellate court. Now, my lord, I am placing the paper book, my lord, the case judgment before your lordship.
Against which?
This appeal.
So the 2 points are Hiba by Meher Afroz, and the second point is that sale
of Abdul
by
Karim.
Abdul. Hmm. Yeah.
No,
This one is the plaint. Thereafter, written
written
statement.
statement, Malad, the point that I have already Malad submitted before your lordship that Abdul Karim, Jarina and Meher sold their entire share by way of deed of 27 July 1946 to the predecessor in interest of my clients, defendant number 1, Hasina.
What did defendant number 2 state in the written statement?
To state Malad, in tune with
Separate-
the
No
plaintiff.
separate written statements.
In tune-
Yes, I'm appealing for defense number 2, my lord. I supported the plaint case basically.
Acha. Plaintiff's case.
Yes, ma'am. There was a LPR my client used to sign without in Urdu language.
Well, that is the matter to be adjudicated by your lordship, Malad, after argument, Malad. Now, Malad, may I place before your lordship the
Yes.
paper book?
Okay.
First, the Malad judgment of the learned judge of the trial court. May I please before your lordship page, internal page 1, I think. Malad.
No, not one. From the last paragraph of page 3.
Last
Defendant
paragraph,
number 1 contested the suit
my lord.
and resisted the suit by filing a written.
My lord, my lord. Defendant number 1 contested the suit and registered the suit by filing written statement and counterclaim. In his statement, the defendant has denied and disputed the material allegations made in the plaint. The written statement of defendant number 1 discloses that Ajijan Bewa was the Thika tenant of the suit property. Defendant number 1 in his written statement has also stated that said Ajijan Bewa died intestate in or around in the year 1944, leaving behind her only son Sheikh Abdul Karim and 3 daughters, Jarina, Meher Afroz Bibi and Hasina Bibi.
So as regards to the year of death of Ajijan,
Ajijan, there is
Bibi,
no
there's
dispute.
dispute.
There is
For
no
44.
My lord,
Sorry, 1944.
1944. The written statement discloses further that by dint of Bengali Kobala executed on 27 July 1946, the said Sheikh Abdul Karim, Jarina Bibi and Meher Afroz Bibi sold, conveyed, transferred and assured their undivided share in the suit property in favor of Hasina Bibi absolutely and forever at a valuable consideration mentioned therein. Sheikh Abdul Karim was a permissible occupier in respect of 1 room, kitchen and veranda in the suit property as a monthly bharataya under Hasina Bibi in consideration of payment of monthly rent as per English calendar. After the demise of Hasina Bibi, this defendant number 1 has become the absolute owner of the suit property. The defendant number 1 requires the aforesaid room, kitchen and veranda for his reasonable requirement and for the requirement of the members of his family. The defendant number 1 had given a notice to the plaintiffs under section 6(4) of the West Bengal Premises Tenancy Act 1997 for ejectment. The plaintiff number 4 duly received the said notice. In respect of other plaintiffs, the said notice has come back with postal remark not claimed. The suit is barred by the relevant provisions of Limitation Act. This dependent has also filed a counterclaim, and in the counterclaim, the dependent number 1 has stated that Sheikh Ahmed Hossein was the owner of the suit property and died intestate on 17th June 1933, leaving behind his wife Azijan Bewa, one son Abdul Karim, and 3 daughters Hasina, Jarina, and Mehera Pooch, who became the joint owners of their respective undivided shares in the suit property. In the said counterclaim, the dependent number 1 has further stated that Azijan Bewa died intestate on 31st October 1944, leaving behind her one son Abdul Karim and 3 daughters Hasina, Jarina, and Mehera Pooch, who inherited her share in the suit property in accordance with law. The counterclaim of the dependent number 1 discloses that Mehera Pooch, sometime in the year 1946, transferred her undivided share in the said property by an oral heba in favor of Hasina, Jarina, and Abdul Karim, and they had accepted the said gift. The counterclaim of this dependent number 1 has further discloses that by dint of Bengali Kobala executed on 27 July 1946, the said Sheikh Abdul Karim, Jarina Bibi, and Mehera Pooch sold, conveyed, and transferred their undivided share in the said property in its entirety unto and in favor of Hasina Bibi, the mother of this dependent number 1. The counterclaim of dependent number 1 further discloses that after the demise of Hasina Bibi, the mother of this dependent number 1, the twice it is written, the counterclaim of dependent number 1 further discloses that after the demise of Hasina Bibi on 14th December 1978, this dependent number 1 became the sole and absolute owner of the suit property by way of inheritance. The counterclaim of the dependent number 1 further discloses that Abdul Karim was a monthly tenant, and after his death, his heirs were allowed to reside in the tenanted room by dependent number 1. This dependent number 1 is the sole and absolute owner of the suit property. The plaintiffs are habitual defaulter, and they have defaulted to pay rent since the month of January 1988.
1 minute. Hasina has claimed that Abdul Karim was a monthly tenant through the counterclaim. Any document has been adduced?
With regard to this,
This? No, she has stated that Abdul Karim was a monthly tenant, and after his death, his heirs were allowed to reside in the said tenanted room.
Malad,
Dependent number 1.
Malad, I shall go through the lower court record. Malad, I told Malad the counterpart of the rent receipts are there.
Are there.
Malad, may I proceed? Malad? This dependent number 1 is the sole and absolute owner of the suit property. The plaintiffs are habitual defaulter, and they have defaulted to pay rent since the month of January 1988. The accommodation available to the dependent number 1 is not sufficient. This dependent number 1 requires the suit property for himself, for his wife, and for his other family members. The dependent number 1 has no other reasonable and suitable accommodation elsewhere. The dependent number 1 issued an eviction notice through his learned advocate upon the plaintiff. As the plaintiff did not comply with the said advocate's notice, this dependent number 1 is entitled to get a decree for eviction of the plaintiff from the suit property, hence the instant counterclaim. The dependent number 2, Jarina Bibi, filed a written statement. The written statement of dependent number 2 discloses that dependent number 1 is creating obstruction in the manner of peaceful possession and enjoyment of the property by this dependent number 2. The written statement of dependent number 2 further discloses that she never transferred her right, title, and title to and interest in the property by executing or registering any deed of conveyance in favor of anybody. The said written statement of dependent number 2 further discloses that this dependent number 2 is knowledgeable in Urdu, and she signs her name in Urdu. The dependent number 2 has further stated in her written statement that she never executed any deed of conveyance, either by signing or by putting her LTI anywhere, and therefore the question of transferring her share in favor of the mother of the dependent number 1 does not arise. The written statement of dependent number 2 moreover discloses that if any such deed is produced, the same is forged and fabricated document created and manufactured with ulterior motive. The defendant number 2 has further stated in her written statement that he has no objection in the matter of effecting lawful partition amongst the co-sharers. The plaintiffs have filed a written statement against the counterclaim filed by the defendant number 1, denying and disputing the material allegations made in the counterclaim by the defendant number 1. It has been specifically stated in the written statement against the counterclaim that by forged and manufactured deed dated 27 July 1946, Hasina Bibi never acquired any right, title to and interest in the suit property. The written statement of these plaintiffs against the counterclaim further discloses that the deed dated 27 July 1946 is forged document and the predecessor of the plaintiffs, namely Sheikh Abdul, was only about 16 years at the material time. It has been stated that the plaintiffs were not monthly tenants under defendant number 1. It has also been stated that their predecessor, Sheikh Abdul Karim, was never a tenant under Hasina Bibi. The plaintiffs in their written statement against the counterclaim have further stated that the deed of conveyance dated 27 July 1946 is void ab initio and is not binding upon the plaintiffs. The counterclaim is otherwise bad in law and is liable to be dismissed with cost. The plaintiffs are entitled to hold share in the suit property lawfully by inheritance from their predecessor, Sheikh Abdul Karim, since deceased. Upon the pleadings of the parties to the suit, 9 issues have been framed. Issue number 1, is the suit maintainable? Issue number 2, do the plaintiffs have any cause of action for filing the suit? 3, was Abdul Karim aged about 14 years when his mother died? 4, did Hasina Bibi to look after the suit property as pleaded in the written statement? Is the deed of sale dated 27 July 1946 void ab initio? 6, do the plaintiff have share in the suit property? 7, are the plaintiffs entitled to get a decree as paid for? What other reliefs, if any, the plaintiffs are also entitled to? 9, is the defendant number 1 entitled to get a decree for eviction against the plaintiff? During trial, the plaintiffs have examined 1 week. Page 8.
Discussion of the issues.
Yes. And all these issues were taken up together for decision. All the 9 issues are taken up together for consideration of the sake of convenience and brevity. Learned advocate appears at the very outset has submitted that the alleged deed of conveyance dated 27 July 1946 is void one. He has further submitted that Sheikh Abdul Karim had not put his signature on the alleged deed dated 27 July 1946. He has further submitted that Sheikh Abdul Karim did not execute the said deed dated 27 July 1946. The signature of Sheikh Abdul Karim on the said deed marked Exhibit E dated 27 July 1946 forged one. The said Abdul Karim did not put his signature on the said deed and he did not execute the same and the signature had been forged. Thus, it is a case of forgery. It has also been submitted by the learned advocate appearing for the plaintiff that the plaintiffs came to know about the forgery upon taking inspection of the alleged deed of conveyance dated 27 July 1946. It has also been submitted that the plaintiffs mailed about the impugned deed from the notice dated 15th October 2003. Malad, your lordship was asking me about the date of the notice. Now, Malad, it is 15th October 2003. Issued upon the plaintiff by the learned advocate for the defendant number 1 and served upon the plaintiff number 4. Learned advocate appearing for the plaintiffs has relied upon Article 56 of the Limitation Act. The starting point of limitation is the knowledge of the plaintiffs. I have carefully gone through the decisions reported in year 1982 in Madhya Pradesh. It has been submitted further by the learned advocate appearing for the plaintiffs that the defendant number 1 in his cross-examination has stated that the counterclaim bears his signature on each and every page. This DW1 has further stated that the contents of the counterclaim were read over and explained to him, and thereafter he has put his signature on each and every page of his counterclaim. This DW1 has further stated in course of his cross-examination that the statements made in subpara C and D of para C of the counterclaim filed by him are not correct. Now let me see what has been stated in at subpara C and D of para 3 of the said counterclaim filed by the defendant number 1. Subpara C of para 3 of the counterclaim of the defendant number 1 states that said Meher approach sometimes in the year 1946 transferred her undivided share in the suit property by an oral heba in favor of Hasina, Jarina and Sheikh Abdul Karim, and they had accepted the said deed of gift. Subpara D of para 3 of the counterclaim of the defendant number 1 runs thus. Thereafter, by dint of Bengali Kobara executed on 27 July 1946, registered in the office of the district sub-registrar at Alipur and noted in book number 1, volume number 45, pages 120 to 126, being number 2603 for the year 1946. The said Sheikh Abdul Karim, Jarina Bibi and Meher Afroz sold, conveyed and transferred their undivided share in the suit property in its entirety unto and in favor of the said Hasina Bibi, the mother of the defendant number 1. And after the demise of said Hasina Bibi on 14 December 1978, this defendant number 1 became the sole and absolute owner of the suit property by inheritance. It has been submitted by the learned advocates appearing for the plaintiffs and the defendant number 2 series. The plaintiffs and the defendant number 2 took inspection of the impugned deed dated 27 July 1946 in court and thereafter detected the forgery of signatures of Sheikh Abdul Karim on Exhibit E, that is the deed of conveyance dated 27 July 1946. It has also been submitted that only after the inspection, the defendant number 2 series detected the forgery of LTIs of Jarina Bibi on the impugned deed dated 27 July 1946 marked Exhibit E in this suit. It has also been submitted by the learned advocates appearing for the plaintiffs and the defendant number 2 series that immediately thereafter they have paid for an order to send the said document to the handwriting expert for finding out as to whether the alleged signature of the Sheikh Abdul Karim appearing on the said deed are genuine or not. It has been submitted further that the handwriting expert had concluded that the alleged signatures of Sheikh Abdul Karim on the impugned deed dated 27 July 1946 marked Exhibit E do not tally with the admitted signature of Sheikh Abdul Karim on the impugned deed dated 27 July 1946 marked Exhibit E do not tally with the admitted signature of Sheikh Abdul Karim. It has been submitted vehemently by the learned advocates appearing for the plaintiff that the defendant number 2 series that the handwriting expert has rightly concluded that the alleged signatures of Sheikh Abdul Karim appearing on Exhibit E are not the
What is mentioned here?
My lord.
It has been submitted further that the handwriting expert had concluded that the alleged signature of Sheikh Abdul Karim on the impugned deed dated 27/7/1946 do not tally with the admitted signatures of Sheikh Abdul Karim on the impugned deed dated same date.
It is compared with the signature in the progress report of the child of Abdul Karim. The progress report from the school, the progress report was sent to the parents. Now, after going through the progress report, now the progress report is signed by the either by the father or by the mother, and then it returns to the school. Now, this progress report signature, it is of 1968 and 69. These those signatures were compared with the signature of the 1946 deed, and it is decided that the signatures of the signatures are not tallied with the 1946 deed. Now, the time gap 1946 and 68, it's a long time. The signature varies from time to time because I'm sorry. I'm sorry.
Fact.
My lord.
That will reveal from the order sheet of the trial court. But what has been written here, is it correct? I
do not. I think the second part of
that line is
impugned. This should be the
what you are stating now. That progress report of
progress.
son.
My lord. That should be my lord. I think. May I proceed, my lord? It has been submitted vehemently by the learned advocates appearing for the plaintiffs and the defendant number 2 series that the handwriting expert has rightly concluded that the alleged signatures of Sheikh Abdul Karim appearing on Exhibit E are not the signatures of Sheikh Abdul Karim, as those signatures do not tally with the admitted signatures of Sheikh Abdul Karim. It has been submitted by the learned advocates appearing for the plaintiffs and the defendant number 2 series that the oral heba by Meher approach in favor of Hasina, Jarina and Abdul Karim is an admitted fact. It has also been submitted by the learned advocates for the plaintiffs and the defendant number 2 series that the aforesaid fact is also the case of the plaintiffs. It has been submitted that Exhibit 9 is the corporation notice issued by Calcutta Corporation in the year 1983, and the same has been issued in the name of Abdul Karim, the predecessor in interest of the plaintiff. It has also been submitted that the said notice issued in respect of the suit property. It has been stated by the defendant number 1 in his written statement and counterclaim that Meher approach transferred her undivided share in the suit property by oral heba, and the same stood accepted by the donees, that is Hasina, Jarina and Abdul Karim. But this defendant number 1 subsequently stated in his counterclaim and written statement that Meher approach along with Abdul Karim and Jarina sold and transferred that undivided share in the suit property in its entirety to Hasina Bibi, the mother of the defendant number 1. Now, can Meher approach execute such a deed when she had no right title to and interest in the suit property at that time, because she has already transferred her undivided share in favor of Hasina, Jarina, Abdul Karim by oral heba, and she admittedly stood accepted. Thus, the said transfer by alleged deed dated 27 July 1946 appears to be tainted with illegality. This defendant number 1 has stated in his counterclaim dated 1st March 2005 that his age is 58 years in his examination in chief on affidavit under Order 18 Rule 4. This defendant number 1 filed on 22nd February 2008 has stated that his age is 81 years. In his written statement filed on 22nd July 2004, this defendant number 1 has stated his age is 65 years. From Exhibit 13, the photocopy of the ration card, it transferred that the age of the defendant number 1 is 58 years.
So one could have disbelieved the submission of the
Submission,
defendant.
since the age are differently written in different documents. Thus, this defendant number was stated his age variously in various places. Hence, this defendant number 1 is not at all trustworthy or reliable. The defense case of defendant number 1 is a mirror of errors. The defense case of defendant number 1 is overcharged with contradictory undertone, and such contradictions are contradictions of falsehood and not the truth. It has been submitted by the learned advocates appearing for the defendant number 1 that the suits should be dismissed with an exemplary cause, as the plaintiff is not maintainable in law. It has been submitted by the learned advocates appearing for the plaintiffs and defendant number 2 series that the central bank appropriated the property from Bhukoilas Devastar Trust as against the mortgage, and the central bank is a nationalized bank. It has been submitted by the advocates appearing for the plaintiffs and defendant number 2 series that all the properties movable and immovable of central bank vest in central government. It has been submitted that government property cannot come within the ambit of Thika Tenancy Act. To them, any land belonging to central and state government are exempted from vest. It has been submitted that the defendant number 1 is claiming the suit property as a private property. So, according to the learned advocate appearing for the plaintiffs and the defendant number 2 series, the defendant number 1 cannot put forward two contradictory pleas in one breath. The materials on record conjointly connote that the alleged deed dated 27 July 1946 Exhibit E is not legal, valid, and sacrosanct one. No reliance could be placed on such void deed dated 27 July 1946. The parties to the suit are entitled to get the decree for partition in preliminary form. With regard to the structure standing at premises number such and such, the plaintiffs are entitled to get a decree for declaration that the purported deed of sale dated 27, it should be July, instead of February. July to 1946 executed in favor of Hasina Bibi, the mother of the defendant number 1, is void and not binding upon the plaintiff. The counterclaim is filed by the defendant is void of merit and bereft of substance. The defendant number 1 is not entitled to get a decree for eviction against the plaintiff as sought for. Hence, the counterclaim is liable to be dismissed, be decreed accordingly. Then, the share has been declared. The plaintiffs do get a decree for declaration that the purported deed of sale.
Now the first appellate court.
First appellate court, affirmed these findings.
Wherein what has been
Page
what has
three.
been dealt with as regards to anything has been discussed as regards to that non-believing the defendant. Yes, page 23, the defendant number 2, Jarina Bibi, has contested the case.
Yes, the discussion has been made with regard to the plaint and the written statement by the learned judge in the lower appellate court, first appellate court. Then, my lord,
Learned counsel. Yes.
then, if you kindly come to page 25.
Yes.
Let's kindly go to in courts of trial. I'm sorry.
Need not read the entire. Issues number 5, 6, 7, 8, and 9. Page 32. Prior to that, anything is required to be placed.
I want to place, if your lordship.
Place the relevant portion.
Kindly come to page 30. Because there is the tika was considered. The paragraph starts with now let me.
Now let us see.
Now let us see whether the argument of the appellant that the civil court has no jurisdiction to try this case has any merit or not. Admittedly, the property belongs to one Bhukoilas Devottar estate and was settled to Central Bank of India. The predecessor in interest of the party, Sheikh Ahmed Hussain, was a Tika tenant with regard to the structure standing thereon on payment of rent. Thereafter, Ahmed Hussain died in 1933 and the property was recorded in the name of his wife Azizan Bewa by a virtue of a registered deed of lease dated 8 September 1939. As per Section 4 of the West Bengal Tika Tenancy Acquisition and Regulation Act 2001, the Tika property stood vested in the state with effect from 1982. The instant suit is for declaration that the deed of sale dated 21st July 1946 is void ab initio, and the defendant number 1 has acquired no title and interest and by virtue of the said deed, and for partition of the structure standing thereon. It is apparent that the case is for adjudicating as to whether the deed of sale dated 27 July 1946 is genuine or not. The court is not called upon to decide or to deal with any question or to determine any matter which comes under the purview of West Bengal Tika Tenancy Acquisition Regulation Act 2001. It has been observed in 2001 CLJ 438 that Tika property is heritable and partiable. It can be transferred among the heirs existing co-sharers. It can be partitioned among the heirs and co-sharers. It was observed in the case that the state of West Bengal should not be unnecessarily implicated in a suit which concerns the co-sharers alone. In view of the same, this court holds that the civil court has jurisdiction to go into the matter and raised in the suit. There is no shared evidence to show that the predecessor of the plaintiff used to pay rent to the defendant number 1 or his mother. The counterparts do not bear the signature of Abdul Karim. The searching slip and the copy of the plaint of title suit number 498 of 1989 do not reflect that the plaintiff or their predecessor was served notice of the suit or they were aware of it. Abdul Karim died in the year 1997 and notice for eviction was sent by the defendant on 15th October 2003. During the lifetime of Abdul Karim, no suit was instituted to his knowledge. As I have observed earlier, that there is nothing to show that the notice was served on Abdul Karim of title suit number 498 of 89. The searching slip exhibit 1 is silent on this aspect. The evidence of plaintiff to the effect that on getting notice dated 15th October 2003, he smelled something and on making an inquiry, they came to know about the sale deed. Appears believable in view of the circumstances and preponderance of probability points in their favor. The instant case was filed in the year 2004 and Article 56 of the Limitation Act will come into play. The starting point of limitation being the date of knowledge of the plaintiff. It is the plaintiff's case that the cause of action arose on 29 September 2003 when defendant number 1 refused to effect amicable partition. It appears that the eviction notice is dated 15th October 2003 and the plaintiff claims the cause of action arose on 29 September 2003 when he asked for amicable partition. The evidence of plaintiff is consistent on the point that he filed the case on being refused partition by defendant number 1. As such, it appears that the case is maintainable and the plaintiff do have cause of action. It appears from Exhibit 3B, death certificate of Azizan Nesha, dated 31st October 1944. It appears from Exhibit 7, which is the voter card of Abdul Karim, issued on 10th May 1995, that his age as on 1995 was 65 years. It appears from Exhibit 8, which is the notice of his employer to the effect that Abdul Karim, having registration number such and such, was to attain superannuation from the service of Calcutta Dock Labour Board on completion of 60 years age on 1st March 1990. The xerox copy of the identity card of Abdul Karim gives his date of birth as on 5th February 1930. It appears from Kabilnama of Abdul Karim that on the date of his marriage on 4th March 1951, the bride Safila Khatun was aged 15 years and the groom Sheikh Abdul Karim was 22 years. In view of his service record, it appears in the year 1944 when Azizun Nesha died, Abdul Karim was aged 14 years. As per voter identity card, Exhibit 7, his date of birth in the year 1930, and when his mother died, he was 14 years. As per Kabilnama in the year 1944, Abdul Karim was aged 15 and a half years. All these three documents points to the fact that at the time of death of his mother on 31st October 1944, Abdul Karim was aged less than 16 years. All these three documents are documents prior to institution of the suit and they have a probative value. Two of the documents, the Kabilnama and the service record, are more than 50 years old and cannot be brushed aside on the plea that they cannot be taken to prove the year of birth of the individual. It is apparent from the evidence on record that Abdul Karim was minor or less than 16 years at the time of his mother's death. It is admitted fact that Hasina Bibi was the eldest daughter of Azizan Nesha and Ahmed Hussain, and they said and she married at the time and residing on the suit property as apparent from Exhibit B, which is the plaint of ejectment case of the year print of ejectment ছিল 19, it should be something.
1946.
1946, there is no suit. There is something wrongly written. She being the eldest sibling, it is quite natural to look after her younger brother and sisters, who were minors at that time. This court holds that Abdul Karim was aged less than 16 years on the date of death of his mother, Azizun Nesha, on 31st October 1944.
He had superannuated in the year 1990, 1st March 1990. He had superannuated
Yes,
on 1st March 1990.
my lord.
So in the year 1930, he ought to have taken birth.
Beg your lordship pardon.
So in the year 1930, he ought to have taken birth.
Yes. Yes.
So at the time of death of his mother, he was 14 and some months, 14 years. And as regards to that registered deed was executed on 27/7/1946.
46. May I proceed, my lord?
Yes, sir.
Issue number 5, 6, 7, 8, and 9. Planet Court below has dealt extensively in his judgment with regard to issue number 5. He has rightly observed that the counterclaim filed by the defendant number 1 on 1st March 2005 in para 3C admitted that Meher Afroz sometime in the year 1946 transferred her undivided share in the suit property by an oral heba in favor of Hasina, Jarina, and Abdul Karim, and they had accepted the said heba. As the share of Meher Afroz was already gifted, there is no question of her selling the same share in the property by registered sale deed dated 27 July 1946, as she did not have any subsisting share in the suit property at that point of time. It was also observed in his judgment that defendant number 1, while deposing as DW1, has stated clearly that the contents of the counterclaim was read over and explained to him, and thereafter he put his signature on each and every page of this counterclaim. This is also plaintiff's case, and facts which are admitted need not be proved. The appellant has argued that the pleadings are to be read, construed, and considered as a whole, and not in piecemeal. He has further argued that the contents of paragraph 8 of the written statement and of paragraph 3 of the counterclaim has to be read together and consistently to give a rational and meaningful interpretation of the entire pleadings of the defendant. It appears from the record that defendant number 1 filed his written statement on 22nd July 2004, craving leave to put a counterclaim against the plaintiff for ejectment. In the written statement, there was no mention of any transfer by oral heba, but in his application under Order 8, Rule 6A CPC filed on 1st March 2005, on oath he made a case out a case of first transfer by heba in the share of Meher Afroz in the year 1946, and thereafter sale of the suit property to Hasina by Abdul Karim, Jarina, and Meher Afroz by a registered sale dated 27 July 1946. As such, the defendant number 1 cannot bypass his admission of the transfer of Meher Afroz of her share in the suit property by oral heba on the plea of rational and meaningful interpretation of the entire pleadings for the harmonious construction, as there appears no ambiguity. He has also argued that at the time of oral heba in the year 1946, Abdul Karim, being a minor, would not have accepted the gift. As such, the gift was initiated by non-acceptance. As per Mohammedan law, the age of majority is the time when he or she attains puberty, and puberty is presumed on the completion of 15th year. As per Indian Majority Act, the only matters in which Mohammedan is not entitled to act on attaining the age of 15 years are marriage, dower, and divorce. On the other matters, majority continues until the completion of at least 18 years. It is apparent in the year 1946, Abdul Karim had not completed 18 years and was a minor. As I have observed earlier, that he was under the care and guidance of his sister Hasina, and she would have accepted the gift on behalf of the minor as per Mohammedan law and taken constructive possession of the same. Considering the admissions of the defendant number 1 in his counterclaim that the gift was accepted, this court holds that the gift was validly accepted. Learned lawyer for the appellant has argued that forgery of deed has not been specifically pleaded. However, it appears from written statement filed by the plaintiff in the response to the counterclaim filed by the defendant number 1 that he has specifically pleaded in paragraph 9. The plaintiff submits that on 27 July 1946, Abdul Karim, predecessor of the plaintiff, was a minor, and at the relevant point of time said Abdul Karim was only about 16 years, and therefore there was no question of any deed of conveyance to be executed by him on 27 July 1946, and the same must have been done by practicing fraud or must have a forged document. It appears clearly that forgery has been pleaded along with another ground that Abdul Karim was minor at that time. I have observed earlier that on 31st October 1944, Abdul Karim was less than 16 years old. As such, on the date of execution of the sale deed, dated 27 July 1946, Abdul Karim was less than 18 years, and as such, he did not have any capacity to execute the sale deed. Moreover, the expert examination report has concluded scientifically and conclusively that on comparing and verifying the admitted signature of Abdul Karim taken in the year 1968-69 with 9 signatures taken from the deed, the signatures appearing on the admitted documents are dissimilar from the signatures appearing on the sale deed. And both these sets of signatures are not the same persons of two different persons. The expert examiner has deposed in this case and has withstood the test of cross-examination. This gives a finality to the fact that Abdul Karim was not one of the executant of the sale deed. Defendant number 2 in the learned court below had filed documents which have been marked as exhibits in support of her contention that she was knowledgeable in Urdu and used to sign documents in Urdu. Learned lawyer for the appellant has submitted that DW1 was present at the time of execution of sale deed, and his evidence to that effect cannot be discarded. It has been rightly observed by the learned court below that DW1 at various times has given different age at various places. As such, his evidence is untrustworthy and unreliable. In his counterclaim on 1st March 2005, he gave his age as 58 years. In his examination in chief of affidavit under Order 18 Rule 4 filed on 22nd February 2008, he gave his age as 81 years. In his written statement he filed on 22nd June 2004, he gave his age as 65 years. From Exhibit 13, the photocopy of the ration card he transferred, his age is 58 years. From Exhibit M, his ration card, it appears that his age is 68 years. From Exhibit Z2, his school living certificate, it appears that his age is 71 years. As such, learned court below rightly observed that this witness could not be relied upon. The learned court below rightly came to the conclusion that the sale deed dated 27 July 1946 in favor of Hasina Bibi was not executed by Abdul Karim and it was void ab initio. Mayor Approach, one of the sisters of Abdul Karim, had transferred her share in the suit property by oral heba in favor of the other co-sharers, and the said deed was validly accepted. Thika tenancy property is heritable property, and as the heirs of Azijan Beba, Abdul Karim, Hasina Bibi and Jaina Bibi inherited the same as per Mohammedan law. Their shares being 2/5 is to 1/5 to 1/5, which subsequently rose to half, 1/4 and 1/4 on acceptance of gift from Meher Approach. The plaintiffs who are the respondents number 1 to 5 in this case are entitled to get a decree for partition in preliminary form with regard to the structure standing on premises number such and such. They are also entitled to get a decree for
So on the same footing.
same footing. And may I come on the next day? and I shall prepare a genealogical table.
Genealogy is required, and apart from that, any submission.
My lord.
On the next day, your submission should be complete. Mrs. Chakraborty, on the next day.
Actually, Mr. Chatterjee is leading me in this matter. Mr. Honorable Chatterjee, senior advocate.
But whenever your lordship pleases, I'm
Next Friday.
Next Friday will be too short because if your lordship asks me to prepare the notes, then
Not the notes.
not
Submission.
submission.
After
next
completion of
Friday,
the-
my lord, if Mr. Rai completes, then my lord, we can come back, my lord, just after the vacation. Or up to Mr. Rai, whenever he is comfortable, and my lord, it's up to completely.
May I can pray, subject to your lordship's kind sanction, and if Mr. Chatterjee agrees, after vacation.
No
Mr.
further
Chatterjee
prayer.
will always agree, my lord. Mr. Chatterjee has never disagreed with Mr. Rai ever. Or your lordship.
Mr. Chatterjee is always busy.
No,
Yes,
I'm
yes.
always available.
Well,
I'm never busy. I'm always that's
So, Mr. Roy, next week you complete on Friday. Thereafter, after the vacation, Mr. Chatterjee. And for the other respondents also.
সবার নাম দেওয়া হয়েছে ঠিক আছে তাহলে নিজেদের প্রজ্বলিকটা দেওয়া আছে প্রজ্বলি রেসপন্ডেন্ট নাম্বার 1
may I leave with your lordship?
Yes.
grateful to your lordship, my lord.
Representative. On behalf of the appellant, commences his submission and submits at length, but could not conclude, and seeks an accommodation to submit further. Let the matter appear on next Friday, 19th of December for further submission.
Grateful.
What is that happening?
Nine appear mulot for Mr. Parthopratim Rai, my lord. Mulot, there's an application for addition of party, mulot. Remembers, mulot, this is that appeal where, mulot, there were 5 defendants in a suit. The suit was decreed.
Suit for?
Suit for declaration that a particular deed is void. So there were 5 defendants. Suit was decreed. All 5 defendants preferred an appeal. All 5 defendants.
Separate?
No, same appeal. All 5 defendants. Appeal was dismissed.
Affirming the trial.
Yes. Second appeal filed, admitted at the order 41 stage. During hearing what transpired,
what are the substantial questions of law?
Mullah would kindly takes up page 94.
Paper book.
This is Mullah Can 4. Well, the application which is appearing in my law list today is Can 4 of 2025. Mullah, page 94 Mullah, has that order. Mullah,
page 94.
94.
Can application.
Can, Mullah, Can 4 of 2025.
Copy. Car copy. Can 4. Old number. এরপরে কি অবস্থা?
Order of admission is 8th of September 2022.
Can put it on. Can put it to Can 1 of 2017 stay or
That is was a stay.
stay?
2 was condonation. Those have probably been disposed of. Subject to correction. This is basically an application for admission for addition of party. Peculiar success.
Find out the application first.
Application.
There must be a thick one.
Yes, something like this.
Motor hull. Let me be clear. First of all, there's another bench at one second. So let us first of search out that application. If possible.
No, probably the file,
Let that
application has reached, but it been tagged. Not been tagged. That is the problem. If the peon is there, he can find it out. It's figured to tag.
Might be there. I got the here only.
Or if we file a department, then it comes.
File in the department.
No, I'm mentioning the code number 21.
It will come out here.
So it will be automatically.
আসেনি তাহলে
It was filed on 2nd of December 2025.
তাহলে চলে আসে কথা
2nd of December.
That's what this online.
Today is 12th.
12. So it.
I can remember 9. The learned councils.
One indulgence can 4 has, I believe, has not been served upon Mr. Roy's class. So I'll serve it.
The application being Can 4 of 2025 is not in the record. Let that application be traced and tagged with the file. Let the matter appear on 9. Acha. Learned Council, Mr. Roy. Affidavit in opposition.
No.
Not required. Acha, तो ताले लिए नहीं.
Probably his consent to it.
Consent to it, everything.
Copy of the same, though the said original application is not in the record. A copy of the same has been served. Which, need not be noted.
Only whether the application is not traceable.
The learned counsel representing the respondent or respondents.
Respondent number 357 to 11.
Respondent's number 3
नहीं, even दीजिए।
311 submits that he does not intend to file any affidavit in opposition to the same. As such, after the said application being tagged with the record, the matter can be taken up for hearing. Let the matter come up under the heading application on 19th of December.
ওটা রিভিশন করে দিন একবার।
তাহলে তো একটা বেঞ্চ আছে।
Well, I did.
জানি হাঁটলে চলবে না।
Mr. Basu, ওটাই তো। ওই
That
as-
matter,
as you-
Mr. Ghoshal has sent me 3 judgments, 3
হ্যাঁ,
references.
হ্যাঁ, হ্যাঁ।
But unless he speak one which point he is arguing, well, I cannot appreciate.
We can comments today.
That thing we are today.
Uh, what to be done?
I don't know.
It is up to
Well,
that side.
It will take some time, at least 15 to 20 minutes time. Today, I do not think my time would buy itself. I am ready. My friend is also ready, I think.
Time is not ready. Everything is in time.
Because we have to try to convince in an humble way your lordship's spiritual conscience.
So I think this is the ideal time.
3:30 is staring at the face, otherwise no problem.
3:30 is there. If I do after 3:30, outside I will be called.
যেদিন ইচ্ছা আমার কোনো অসুবিধা
আমার
নেই।
তো
Matter appear on 19th as item number 1 at 2 p.m. Fight the earlier ordered. That is the problem.
But in spite of our best efforts, it takes 10 to 15 minutes extra time from Khudiram statue to Surya Sen statue. It takes 15 minutes extra time.
During the morning.
Well, he's a VIP man. He doesn't require it.
doubt.
No doubt. That is why I'm saying.
VIP came to my location.
So can it be fixed at whether time is required to be mentioned at 11 or
My lord probably has applied a lordship's mind. Only Mr. Ghoshal will argue for 10 minutes. I will reply.
it means half an hour is required altogether.
Ultimate half an hour.
Let the matter appear on 19th
Yes,
as item number 1. Thereafter,
Morning.
in the morning.
That is also not.
No.
My lord is in division bench.
No, 19th Friday.
Oh, Justice Subramanian.
19th Friday
Morning.
in the morning. If there is any problem, then let a Passover be.
That can be done.
That we know. Let it be there. Let it be there.
Otherwise, the matter is pending since long.
Wider scope.
No, we have already argued the matter.
Mhm.
My lord could not sit singly. That's the point.
Just to
Whatever may be
frankly
the
speaking,
explanation.
much water have flown down the Ganges to refresh the memory by recapitulating some points and pointing out some point left out. না ঘন্টা অত বলতে পারি না ওই যে ছোটখাটো লোক।
Councils, refreshment is not required. Only the points which you intend to.
My lord, I am grateful. My lord may not require it. We may require it. Anyhow, I assure I shall be very short.
And I am as usual thought.
Let the matter be fixed at item number 1 as item number 1 on 19th.
If I
Let there be,
don't have the problem, I will be there. No problem.
if there is any problem, let there be someone
Yes,
to
yes.
seek
That we know.
Passover.
I'll be
Matter
here.
can
I'll be
fixed at-
here. And my friend.
Can be fixed at 11 or 11:30 on that.
Yes, yes.
So that it can be completed on 19th.
Yes.
এটা শুনুন
দিয়েছে তো আমাকে 3টে judgment পাঠিয়েছে। আরো আছে?
নোট করে নাও।
no, those have been mentioned in the written notes of argument.
Yes. These three is not there. Earlier on, there's there. We have searched also on the question of judicata. That's found some Supreme Court judgment.
Section 11 CPC. How many judgments required?
No. That is the only point of the appeal.
Only point. 6 judgments
Only
required.
point of court, because Learned Appellate Court has not dealt with anything except in res judicata. Res judicata doesn't apply because no suit against me, no degree against me, no evidence, no pleading on my part. Still, I have been held up for res judicata. No other point has been discussed.
I am indicating the point. Lower Appellate Court has not gone into the merits of the case only on the ground that there is a judicata. I will not touch. If ultimately my lord is the opinion, Lower Appellate Court was wrong, then there is no other option but to remand this matter.
Yes. Yes,
But
that's
as
there.
far I am concerned, I am too confident. The lower appellate court has rightly decided the point that he was a party in the proceeding. That's why the judgment which is there, favor or against, binds him.
I said so is not.
Let us, that man will decide.
Then I have so it just the reverse.
This is our job. My job is to make it correct.
Yes, yes. I'm grateful for my learned face opening his mouth. This is the point I want to distinguish. Any that no relief was sent against me, no pleading on my part, no adjudication on my part. So still I have been adjudicated, not suited. And only on that ground I have been non suited. Series of unchallenged degrees are there, orders are there. But no degree against me in that sense. Because I have no pleading is there, no I didn't appear, no summon, no adjudication, no issue framed. And the order is very clear. No, my lord is something kindly permit me to try explaining in my humble way. I cannot see.
Yes, before this bench, everybody gets the sufficient time.
That's right.
Nobody can
That I know why.
claim that.
More than
That is becoming trouble from
yes.
on this end. On this end.
Has to be. If you are giving indulgence me, I will not stop.
The learned senior counsels representing the appellant and the respondents, though are ready to apprise the court, but due to paucity of time, the matter could not be continued. Full stop. Let the matter appear on 19th of December 2025. এটা এক নম্বর আইটেম দেবেন বুঝেছেন আইটেম নাম্বার 1 এ থাকবে এটা টাইম কিছু দেওয়া থাকছে না এক নম্বর থাকবে
Especially when I face Mr. Basu, I must be very careful.
Compliment না ভয় লাগে কি কোনটা
Why the dog?
No court officer ever asked us to give your name. Now, without sleep, never entered into a I'm not blaming anybody. System has been changed.
Item number 10.
I don't know why.